Good morning, Kiara. Good morning, Sherisku. Good morning. Good morning, Leo. Thank you very much for joining me. Let's have a few more come in. Some more people are joining us. We had it, although I doubt we will be joined by any of them. I have a partnership with the Costa Rica Bar Council, and for some reason, the news was posted in Costa Rica 48 hours ago about this course. Now, it's 3 a.m. in the morning in Costa Rica time, so I don't think they're going to join us, but 150 people from Costa Rica suddenly applied to register for this morning's lesson. I don't think we'll actually see anybody, but let's see what happens. Good morning, Khaled. Good morning, Catherine. Hi, Slavik. Thank you for joining us. Okay, well, we'll begin. Let me first of all tell you what we're going to look at. Over the last few weeks in the law company in Dubai, I've had to provide a number of webinars relating to the effect of coronavirus on business. As you can guess, those of you with any experience of contract law will know that this is what is called a force majeure situation. Well, force majeure in virtually all circumstances. And because we're dealing with various legal regimes here in the UAE, including common law courts at the Dubai International Financial Center and the Abu Dhabi Financial Center, and Sharia courts in the rest of the UAE, and also legislative principles that overrule the Sharia principles, it becomes quite complex. It's become even more complex when you consider that the governments have felt that despite the lockdown applying to virtually everybody else in the region, construction work must still go on. So construction workers living in dormitories are still meeting on building sites. So the situation is very confused. I've had to give a number of webinars to try and explain the situation. What people don't see in relation to force majeure is that there is another area of law which coronavirus can also cause to come into effect. And this is part of the common law, and it's the doctrine of frustration of contract. Frustration of contract. I'm going to give you a little 10-minute lecture on frustration of contract, because this is how it works in the common law jurisdictions. As well as having force majeure, if force majeure may not apply, frustration of contract may apply. So we're going to have a little lecture on that. And then after we're done with that, I want to look at word formation. You know that an adjective can usually be changed slightly, so it becomes a verb, or it might be changed from a verb to become a noun. It's important in your legal writing that you're able to change these words around to make it a noun or an adjective or an adverb. And so we're going to have a little bit of practice with that, with some frequently used legal words. And then I want to deal with a bit of legal English vocabulary. As usual with the vocabulary, there's more in the presentation than I'm going to deal with in the class, otherwise we'll never finish. But we'll go through some of that, and we'll have a little exercise at the back of it as well. All right, so I'm afraid the first part isn't going to be too interesting because it's going to be a lecture, but I hope the topic is interesting to you. And it's good practice of you to listen for legal English. Okay, well, let me share my screen and then I'll begin. Well, as you can guess, this is part of one of the lessons from our contract law course. This is quite a well-attended course. I recommend it to those of you who want to study comparative law or who may intend to become contract drafters, because you must understand the law before you start to draft the contracts. Now, frustration of contract. Now, if a contract is made, and for whatever reason it later becomes impossible to one party to perform their obligations, we need to think about frustration. Why is it impossible? It may not be impossible for force majeure, it may be some other reason. Now, be careful to note that frustration is about subsequent impossibility that occurs after the contract is made. If the contract was impossible to perform even before it was made, then that's a matter of mutual mistake, not a question of frustration. If I say I'll sell you my racehorse for $10,000 and you agree, but unbeknown to both of us, the racehorse died yesterday, that's a question of mutual mistake. Neither of us can get what we want. You should first establish whether or not the particular situation in question has been provided for in the contract. The contract is your instruction manual. Always, whenever there's a problem, turn straight to the contract. Look at the instruction manual, see what the contract says. Now, usually, this sort of situation for frustration, if it's covered in a contract, is covered in a force majeure clause. Now, force majeure isn't part of the common law. If you've got a common law contract, then you have to write a force majeure clause into it to use force majeure as an excuse for not performing your obligations. Whilst it's often implied in civil law countries, it's not implied in the common law. You have to write the specific force majeure clause into the contract for it to be effective. Here's an example. Common law contract for the sale of some goods which are going to be delivered by ship. Might say, in the event of the cargo being lost at sea, this is what happens. Now that's the way to draft a contract. Look ahead to what might go wrong, think of the problem it will cause, and then put the solution of the problem into the contract. And here that's what the contract draft has done. In the event of the goods being lost, this is what the parties will do. Now, a force majeure clause is only valid if the provision is full and complete. That is, it has to be very specific about the risk that's being provided for. If there isn't a force majeure clause, then maybe frustration will apply. There are three sorts of frustration, and you've got to look at which type it might be. First, supervening illegality. Well, this is where the government step in and change the law after the contract has been started. Best case on this is way back 160 years ago, at the time of the Crimean War. Britain and France go to the aid of Turkey and invade the Crimea and fight with Russia. Well, a ship was meant to dock at the harbour in Odessa, which of course is now part of Ukraine, and pick up goods. With the outbreak of the Crimean War, it's illegal under common law contracts to make a contract with a citizen of a state with which your country is at war. Well, obviously the owner of the port in Odessa was a citizen of the country with which Britain was at war. So it made it illegal to load the cargo from that port. The government said so. They made a new law to make it illegal to trade with enemies. And so that supervening law made the contract illegal. That frustrated it. Next, further performance of the contract might become impossible. Why? Well, the actual subject matter of the contract, for example, the premises which you are leasing, might be burnt to the ground. Or, if it's a person, perhaps they're sick or dead. Or you hire a famous band, but the lead singer is taken ill and can't perform. Or the lead singer's in Dubai, for example, where the airport is closed and he can't get away to perform at your concert. Or the nature of the contractual obligations becomes significantly different from what was agreed. I don't mean it's just a bit more difficult. I mean, it destroys the basis of why you entered into the contract. The best case I can give you as an example is the case of Krell and Henry from the UK, reported way back in 1903. You can understand the situation. In 1901, the old Queen had just died. Queen Victoria had died, and her son, Edward VII, was going to be crowned. There was going to be a huge coronation. Emperors, presidents, kings, princes, maharajas were going to arrive from all over the world, from every dominion of the British Commonwealth. There was going to be a fantastic procession of bands, emperors, celebrities, shall we call them? It's going to take several hours to pass. And Mr. Henry hired a room for the day in a huge apartment overlooking the main parade. Well, unfortunately, the prince fell ill. And so the coronation couldn't go ahead. It was postponed till 6 months later. Mr. Henry then said, well, I don't want to pay for the apartment. Mr. Krell, the landlord, sued him. Well, the contract, the court felt, had been frustrated. That is the purpose of renting the apartment. The purpose was to look out on the parade and enjoy it. Now, the contract wasn't impossible. There's no reason why Mr. Henry couldn't have gone into the room, taken a chair, and sat and looked out of the window all day at the people walking past. But it's not the big parade. The whole purpose of the contract has been frustrated. The contractual obligation, the contractual basis has become significantly different from what was agreed. The courts agreed it had been frustrated. Hadn't become impossible. Mr. Henry could still go there with his pals, but there's no purpose. So there's also a fourth reason. Again, it's the supervening illegality type. It's where the government intervention of some sort, like a lockdown, makes it unreasonable for the parties to carry on with the contract. Right, let's say you enter into a lease of a shop in a shopping mall. What's the purpose in entering into a lease? Well, it's to display your goods so that members of the public can come in and hopefully purchase some of them. Well, you take the lease, but then the government says that due to some sort of medical emergency, the mall will be closed for 6 months. Well, that's defeated the purpose of taking the shop. Your purpose has been frustrated. Now, if it's only closed for a week, that hasn't completely destroyed the basis of the contract. If it's closed for a year, that probably has. So it's a question of fact and degree in every case. Now, there are some points to be careful of. A contract isn't frustrated just because it becomes more expensive or more difficult. That's the risk you take when you enter into a contract. What you're looking for here is some sort of physical impossibility, some event which also must be beyond your control or control of the other party. And the event must be unforeseeable. That's where it differs from force majeure. Force majeure events are not expected to occur, but they can. For example, I want to buy oil to be delivered by pipeline through Siberia, where it can reach -45 in the winter. It will be quite foreseeable for the pipe to crack for 2 hours, which prevents delivery for 2 hours. It's a force majeure event even though it only lasted 2 hours, and it was foreseeable. We hoped it wouldn't happen, and we took steps to try and make sure it didn't happen, but that's force majeure. Whereas supervening event has not only got to be beyond our control, it's got to be unforeseeable. Now, the legal effects is the contract is automatically brought to an end. If you don't put a provision into the contract as to what's to happen if the event occurs, the contract terminates. If there's been some sort of prepayment, then the person who made the prepayment can get their money back, minus any expenses from the other party. If the other contract has already been performed, then it's more complex because the goods have been consumed, the money's been spent. What will happen here is the goods or money will be returned so far as they can, and the party that has benefited will have to pay for the benefit they've received so far. For example, you wanted your entire garden landscaped. The landscape gardener came in and just started by building a swimming pool. It hasn't done the rest of the work. And now they're prevented somehow. Well, you got to pay for the swimming pool, even though the rest of the contract is frustrated. So frustration's a kind of defense. Let me just see that question. Is there a provision in common law contracts for frustration? Well, frustration, well, yes and no, in the sense that frustration, of course, has got to be something you can't foresee. So how could you write about it? What you could do is you could attempt to exclude the legal effects of frustration, but as you can't foresee what the frustrating event is, how could you write about it in the contract because you don't know what it is? What you could do is think ahead and say, if any unforeseeable event does occur, this is what the parties are to do. Okay. Now, so frustration of purpose occurs when the underlying purpose for the contract becomes impossible, and both parties knew of this principal purpose. For example, I want to lease your concert hall to have a rock concert, but unfortunately, the lead singer of the rock concert has fallen ill and is not available. Well, we both knew why I wanted your concert, so the contract's frustrated. It's also known as commercial frustration. Right. Now, this doctrine of frustration is also closely related to the doctrine of impossibility. The doctrine of impossibility concerns duties specified in the contract, whereas frustration concerns the purpose. Let me give you a rather silly example. Let's suppose there's an entrepreneur called Emily. She wants to open a restaurant, so she leases space for a restaurant from a landlord, Larry, because she's worked out that she has got a special diet whereby she's only going to serve Tibetan speckled lizard meat in the restaurant. Right. Now, if the city council rezone the property to forbid commercial use, well, that makes the contract impossible to perform. If the property is destroyed by a tornado, that also makes the contract impossible to perform. And both of those would probably be force majeure events, right? It's impossible because of force majeure, supervening illegality or act of God. But let's say instead the Tibetan speckled lizard goes extinct. There are none left in the world. Well, then now there's the whole purpose of having the restaurant was to serve Tibetan speckled lizard meat. As there are none left in the world, the purpose of the contract, the purpose of taking the restaurant is no longer possible. So it's frustrated. Emily could still take the premises, but what's the purpose in taking a restaurant when the whole purpose was only to serve one particular type of meat? Contract is frustrated. And different countries have tried to pass statutes. Here's one definition from an act of parliament in one particular country, where, after a contract is made, party's principal purpose is substantially frustrated without his fault by the occurrence of an event, the non-occurrence of which was a basic assumption on which the contract was made, so the parties weren't expecting it. His remaining duties to render performance are discharged unless the language or circumstances of the contract indicate the contrary. In other words, somehow somebody has put a provision in to say what will happen if the contract is frustrated. All right. Now, a circumstance is not deemed to be a basic assumption on which the contract is made unless the change in circumstances could not have been reasonably foreseen. So it's rarely invoked successfully because we didn't know it was coming, so we couldn't write about it. These sorts of frustrations usually come in waves, at times of social upheaval, such as the passing of the Prohibition Act in America, where the bars and restaurants could no longer serve alcohol. So what's the point in having a pub if you can't serve alcohol? Or the repeal of prohibition, where suddenly you can have alcohol. Times of terrific tumult, like major wars, or quite frankly, during the COVID-19 situation, where the demand for goods and services falls far below normal. If successfully invoked, the contract is terminated and the parties are left as they are at the time to either litigate, arbitrate, or settle. All right, let's leave that. Right, now I want to deal with something from our legal English course. Something a bit lighter, okay? Short exercise involved in this to get you a bit more active. It's very important that you're able to form legal words from other legal words. So take an adjective and make a noun from it. Take an adjective, make an adverb or a verb from it. So in both legal and general conversational English, it's quite usual to form nouns, adjectives, verbs from the root of the same word. In legal English, this often causes a problem because the source of the word might be Norman French or Latin, or even ancient Norse, the Viking language. Because these words don't appear in everyday conversation, forming other words from them can be difficult. We're not used to it. So in this lesson, in this section, we're going to look at some of these words to have some practice. Here's a slide. You can see the verb is on the left, to administrate, and the abstract noun for the process is administration, and the personal noun of the person who does it is the administrator. Well, some words are very tricky. Who audit a company's accounts, and the noun for the process is again audit. The person doing it is the auditor. To liquidate a company leads to the liquidation of the company, and the person doing it is the liquidator. To perpetrate means to do something bad. Perpetrate a crime, the perpetration of a crime is the process, and the person doing it is the perpetrator. Now, you'll see some of these words don't have personal nouns. To appoint leads to an appointment. To assume leads to an assumption. We don't have an assumptor. To authorize leads to authorization. We don't have an authorizer. To form leads to formation. To issue leads to issue, same, which gives rise to an issuer as the person. To omit leads to, notice the change, leads to omission. Notice the T becomes a double S, omission. And there's no such thing as an omissioner. To provide becomes provision. And as the noun for the person, the provider. You see how it jumps around, it's not easy. To redeem, that's paying off a debt, leads to redemption, and the person doing it, the redeemer. And to require leads to requirement. There shouldn't be any such thing as a requirer. Now, it's boring for me just to go through these, reading them. So, you can see how it works. Now, in the next slides, I'm going to leave some gaps. You're going to tell me the answers. Right, preempt, meaning to preempt you. It means to stop you before you start, leading to the noun for the process of preemption. Fine. So to refuse something leads to what? What's the noun for the process of refusing? It is what? Write it in the chat box for me. Nothing too difficult on this slide, okay? Just a bit of easy practice. To refuse leads to a what? Let's have a look here. Good, refusal. Well done, Elenia, Catherine, Vincent, Cherise. Good. To consolidate leads to consolidation. What to divide leads to? Divide leads to nothing too difficult. What is it? You should all get this one as well. Let's have a look. Division. Great. Very good. Very good, Mahmoud. Division. To resolve, meaning to make a decision by the shareholders or directors in a meeting, leads to a resolution. To diversify meaning to spread into different areas, leads to diversification. To amend leads to an what? Amend what? Amendment. Very good, Catherine. Slavic. Anna Bernard. Ah, good. Kiara. Excellent. To rely on leads to reliance. We turn the Y into an I, reliance. To issue, when we're talking about the issue of shares, it leads to an issuance. Now, if it's the issue of a newspaper, it leads to issue, an issue of a newspaper. But if it's relating to shares, we use this old-fashioned verb, an issuance. Right. Here's some more now, this time verbs to nouns. To distribute or distribute. You'll notice I've underlined where the stress should be. Both are correct. Leads to distribution. To merge two companies leads to a merger. To regulate leads to what? What is the noun for the process of regulating something? Good. Let's have a look. Regulation. Ah, too easy for everybody. This is great. Very good, Catherine. Very good, Abdullah Kafar. Very good. To submit leads to submission, approve to approval, consolidate to consolidation. Now, if you're going to acquire a company, acquire, Latin, right? To get, acquire, leads to acquisition. Liquidate leads to what? That means to close a company down because it can't pay its debts. To liquidate, turn its assets into cash and pay the creditors. To liquidate leads to a what? Let's have a look here. I think you've all got it. Oh, 13 answers. Liquidation. Oh, excellent, everybody. Khaled, Sharice, great. Slavic, yeah, great. And to cancel leads to cancellation. All right. Easy stuff so far. Let's go on to something a bit more complex. I won't bother with the ones which are already done because you can read them. Look at intend. Intend leads to what? Anna Bernard is good. Intention. Well done, Vincent. Intention. Intention. And to violate leads to what? You see this on all the American police shows. Violation. Oh, yeah, it's too easy for everybody. Okay, let's jump ahead. With delegate leads to delegation. Now, that leads to a delegate attending, a delegator doing it, or a delegatee being the person delegated to do it. Notice how the pronunciation spells delegation and delegate. And the person doing it, delegator. And the person it's being done to, delegatee. Look at assign. To assign a contract leads to an assignment, with the assignor, the person doing the assigning, and the assignee. An obligation under a contract. You have to oblige them. And it's person performing the obligation is obligor. Person receiving the benefit, obligee. Okay. Rebut leads to rebuttal. Construe leads to construction, meaning the understanding. The construction of a contract doesn't mean the way it's formed or its structure, it means the way we understand it. To determine means to decide, which leads to a determination. Right, let's move on. Here are some verbs and here are some nouns. Disclaimer, disclaimer. Exclude, exclusion. Indemnify, indemnification. Tolerate leads to what? A bit more advanced. Tolerate leads to what? Yes. And there's another. Tolerate leads to toleration and also another version of the word toleration. What's a shorter noun to describe it? Anybody tell me what the shorter noun is? The second noun for tolerate? Let's have a look at your answers. Tolerance. Excellent. Well done, Liang Zhang. Well done, Cherise. Tolerance. Postpone. Right, what's postpone? What's the noun for postpone? Oh, great, you're still, plenty of you still answering. Let's see how we're doing. 6 of you. A postponement. Very good. Good, Charisse. Good, Slavic. Postponement. Postpone leads to postponement. Right, now, let's turn a verb into an adjective. Suit becomes suitable. Accept becomes acceptable. Imply becomes what? Trick question, really. It's not impliable, okay? It becomes what? Let's see what we got. It becomes implied, okay? It becomes implied. That's a trick question, okay? Implied. Bind becomes binding. Ascertain, which means to learn, to discover the facts, becomes ascertainable. And now, let's turn some adjectives into adverbs. You know that usually you can turn an adjective into an adverb, usually by putting ly. Sometimes double ly, but usually putting an ly at the end of the word. Sometimes you have to add a couple of extra letters like this. Basic becomes basically. Electronic becomes electronically. Principal, which means the main thing or person or the amount of money lent or owing in a debt, the principal sum. What does that become? Principally. Excellent, everybody. Very good. Oh, very good. Okay, let's jump ahead. Strict becomes what? Pretty easy. The rule will be enforced how? What's the verb is enforce, the adverb is strictly. Oh, great. Well done, Elenia. Well done, Flavik. Excellent. Okay. Yes. As you can see, there are not many reliable conventions in changing the words from verbs to nouns or changing them from adjectives to adverbs. I'm afraid, as usual with legal English anyway, is to constantly practice them. As you can see, you look at other examples and think I'll follow the same rules, put ation on the end, and it turns out to be ably. So it's constant practice. All right, let's move on. I want to deal with some legal vocabulary. Now, I'm going to go through about 7 or 8 of these, and that's all. And I'm going to make this available for you to obtain from our website, from at the end of the lesson. Now, culpable negligence. Negligence, of course, means being negligent, which means more than being careless. It means being careless beyond the scope of carelessness of a reasonable person. Culpable negligence means negligence which can be blamed. Basically means recklessly acting without reasonable caution, putting another person at risk of injury or death, or failing to do something which has the same effect, like an employer not having a safe working environment for their building workers. For example, you might hear the car hire company was found to be culpably negligent for the accident, as they had failed to check the car's brakes before hiring the car to the claimant. Caveat, Latin word, of course, it means caution. A caveat is a noun. Caveat is a formal notice filed with a court or officer of the court to suspend a proceeding of some kind. Could be the registration of a house, could be court proceedings, but it's to suspend a proceeding of some official kind until the person filing the caveat is given a hearing in front of a court. It prevents dealing with the property, like a sale or a mortgage, until the person registering the caveat can be heard by the court as to why their interest should be taken into account. For example, the house sale was stopped when the purchaser found that a caveat against dealing had been entered on the land registry in respect of the house. Certiorari. This is a type of court case brought in the common law. Obviously, it's Latin. Certiorari is a type of common law writ issued by a superior court to a lower court, demanding the lower court's record of the particular proceedings of a case. The superior court's going to see what happened at the lower court. It's usually used to check the lower court's proceedings were correctly conducted and it did not overexceed its powers. For example, the High Court issued a writ of certiorari against the tribunal to check the claim that the way it had dealt with the unfair dismissal claim had been conducted unfairly. Contravene means to go against the rules and the laws. For example, he contravened the speed limit in his car. Damage. Now, damage means the loss caused by one person to another or his property. For example, I suffered £2,000 damage to my car because of his bad driving. I've put that word there because I want to contrast it with damages with an S. Damages has a totally different meaning. Damages is the financial compensation awarded to someone who suffered an injury or was harmed by somebody else's wrongful act. It's the amount of money ordered to be paid by the court from the person who's done something wrong, usually to be paid to the person who's been injured, who suffered the harm. For example, the court awarded me £2,000 damages in compensation for what Mr. Smith did to my car. Or I will go to court and ask for damages. Now, actual damages, because there's lots of different types of damages. Actual damages are real damages, ordered to compensate for loss or injuries that actually occurred, as opposed to nominal damages, which is a tiny amount ordered to be paid where somebody's won a court case but there's no real loss. Or punitive damages, ordered where the judge wants to signal their disapproval of the way in which the complainant has conducted themselves. What they normally do is they award them £1 in damages, but then make them pay all the costs of the case, which could run to hundreds of thousands of pounds. For example, the garage bill for repair to my car was £1,500, and the court awarded actual damages of £1,500. Compensatory damages. This is the amount of money needed to compensate a person for any actual damages caused by the party against whom the order is given. There are also awarded for things that are more difficult to measure, like pain and suffering. His bad driving resulted in me being injured and I broke my leg. It hurt a lot. So I want compensatory damages for the pain and the suffering. And they got consequential damages. Very important. They're damages or loss which arise not from the immediate act of the party that caused the problem, but it's a longer-term result. For example, if one man injures another through his negligent driving, so that the man who's injured loses his employment and therefore his salary, well, the consequential damages will be the loss of the salary. Perhaps also he had to employ a nurse to look after him for 2 months. Well, you'll have to pay the salary of the nurse as well. That's consequential damages. And then contingent. Contingent is a word often used in legal English. It means depending upon whether it happens or not. It depends upon a doubtful event. It might occur, it might not occur. We call it a contingent event. For example, whether we pay in full is contingent upon the goods arriving in time. Or payment in full was contingent upon good work being performed. Contingent damages, well, these are given where the issue or argument is made and no argument against it is raised. We call an argument against it demurrer. Demurrer. I demur, that's the verb, from your argument. I would say in my argument, the opposite was true. That's demurrer. The judge decided that the loss was £10,000 and awarded contingent damages depending the outcome of the trial as to compensatory negligence, how much the person who was injured was themselves responsible for the damage. Right, let's jump ahead. General damages. Damages which the law implies to have arisen from the act of the person who caused the loss. For example, assaulting somebody. You get awarded general damages without actually proving the extent of the harm. For example, I was awarded £1,000 general damages in respect of his assault on me. I didn't have to point to a black eye or a broken leg, just prove that he assaulted me. Now, let's have a little exercise. Here is one of the words we've looked at, a caveat. What is it? Is it 1, 2, 3, or 4? A charge over land to secure repayment, a dangerous legal argument, or a registered warning against buying or selling something, or a warning not to sell land? Is it 1, 2, 3, or 4? Let's see. Now, is it 1, 2, 3, or 4? All right, let's see what we've got. It is 3. It's 3. It's a registered warning against buying or selling anything, really, not just specifically land. You'll have a caveat entered on land. That's what we call the distractor, number 4. It's almost right. But in fact, it's a warning against buying or selling anything. Could be granting a mortgage. Right, let's have a look at the next one. What are contingent damages? Is it A, a court ordered to pay money which may or may not be ordered? Is it B, damages for something that may or may not happen? Is it C, compensation for unexpected losses? Or is it D, court order for damages for items which are not contested? Let's have a look. It's okay. Well, you've got a lot of wrong answers. Let's go back to contingent damages. Let's go back to the slide, okay? They're given where the issues or counts or claims to which no argument has been filed are tried before any question of argument to parts of the claim. For example, you decide the amount of compensation, then you'll decide how much the person who's going to be awarded the money, how much they were to blame for the thing which occurred, how much will reduce the amount of the award by. Let's go back, okay? Their court order for damages for items which are not contested. It's not contested that this is the amount of damage suffered. What is contested is my percentage responsibility in causing it to happen. All right, let's move on. Maybe I didn't explain that too well. What is the legal meaning of the word damage? Is it physical harm to somebody, loss caused by one person to another? A, B, C, or D? Okay, well, yeah, it's B. It's the loss caused by one person to another or another's property. The harm you've done it. Let's have a look at that. Yeah, okay, B, very good. And lastly, what is a writ of certiorari? Certiorari. A, B, C, or D? Again, don't rush. Let's see what we've got. It's A. Great, everybody's got it. Well done, Elena, Khalid, Abdel Ghaffar, Catherine. Well done, everyone. Sarah, Khalid, excellent. Well, that brings me to the end of today's lesson. Now, that brings us to the end of this short course. Where I am, the lockdown is now finished. People are returning to work, is busy again, so I can't really keep broadcasting these lessons. I've taken extracts from 4 of our pre-recorded video courses to add into these lessons. Our legal writing course, our legal English course, contract drafting course, and the contract law course. I want to thank everybody that's attended today, and although they won't know of it, perhaps they'll watch the recording later, I'd like to thank everybody that's bothered to take the time to watch these recordings. Thank you very much for trusting me with the important matter of your legal education and your professional skills. I would love to see some of you in the future as students of the British Legal Centre. We're starting new courses all the time. We have our legal writing course and the contract drafting course starting again in the next few weeks. Sarah, when can we receive our certificates? Well, I'm glad you asked me that, Sarah, because I've forgotten to mention it. The only way really I could give you a certificate would be to set an exam and to ask you to pass it. And quite frankly, we didn't really intend to set an exam. These lessons are really put here to give you encouragement during the period of the lockdown. these lessons are what they are, free lessons. I hope you've enjoyed them. I hope you found them useful. I haven't charged you for broadcasting them, but I'm very grateful for you trusting me with your time to improve your legal English and legal English skills. Now, thank you, Cherise. That's very kind of you to say so. Thank you very much, Sarah. Thank you, Slavic. Thank you very much, Elenia. What about a paid exam? Well, Abdul Ghaffar, let me explain if I may. Abdul Ghaffar has asked me about a paid exam, a paid certificate. Abdul Ghaffar, I was thinking of making paid exam possible, but this is a free course and it feels very bad. I'd feel very hypocritical. I'd feel not hypocritical. I'd feel like I'd deceived you if I said the course was free, but you have to pay at the end to take an exam and buy a certificate. This is a free course, and that's what it is. The whole purpose was to improve your knowledge and your skills, and I hope it did so. I didn't intend to make a profit out of anybody from doing so. So all our other courses are available for you to study. We'll give you a discount if you've been attending this last lesson because we know who you are. But those will have an exam and a certificate at the end. This short course really is just what it is. Thank you very much for attending, everyone. And I hope you'll become students of the British Legal Centre in the future. Thank you, Abdul Ghaffar. Thank you, Leah. A pleasure to have you as a student. Thank you, Catherine. It's very kind of you to say so. Thank you, Leo. Vincent, thank you very much for this. Thank you very much, Vincent. And Catherine, it's very nice of you to say so. Thank you, Leo. I suppose you can see these comments. And Anna Bernardis, thank you. Yeah, thank you, Anna Bernardis. Thank you, Barbara. I'm glad you enjoyed it and I'm glad you found it helpful. Anna Bernardo, all the best. All the best to you as well. All right, thank you, everybody. Hope to see you in the future. I hope you become students of the British Legal Centre on one of our other more specialised courses. Otherwise, I hope you all escape from lockdown soon and life returns to a semblance of normality for all of us within a month or two. Thanks very much, everyone. Let's just see the rest of these messages. Thank you, and all the best to you, Anna. Thank you very much, Jakub. Thank you, Matthew. Oh, wow. Leon, thank you very much for saying this. I'm glad you appreciated the course. And I thank you, Leon. I was very happy to have you as a student as well. And Kiara, thank you very much for saying that. Thank you very much for attending the lessons. It's very nice to get messages like that. Well, let's stop sharing so I can see everybody on the screen. Oh, yes, everybody, join me on Facebook and LinkedIn if you would. Join the British Legal Centre on LinkedIn as well, and on Facebook. We can keep you informed about things, special offers, new courses, live training events, all sorts of things. Right, I'll close that. I've got to get ready for my next official broadcast a little later this evening. Thank you, Jaco. It was a pleasure having you as a member of the class.
Goodbye, Mr. Richard. Have a good day.
Goodbye, Leon. Thank you very much. Thank you very much for your nice get some honey tea, Mr. Richard. Thank you very much for your thoughtful suggestion. Okay. Bye-bye. Bye-bye.
Bye-bye. Good day.
Bye-bye.